Good evening and welcome to the Municipal Platting Board meeting for Wednesday, February the 2nd, 2011. Will the Secretary please call the roll?
Lendl Story.
Here.
Hold on just a second. Oh, there we go. Lendl Story.
Here.
Sorry. Steve Abel. Ken Fuller.
Here.
Ellen McKay.
Here.
Anastasia Taylor.
Here.
Jody Moses.
Here.
Daniel Young.
Present.
Brent Cole. Amy McKenzie.
Here. Thank you. We have a quorum, and just want to let you know that we're having some technical difficulties this evening, so there will be no facility for overhead today, and there are a couple of corrections that we need to make to the agenda. On the front of the agenda, the vice chair position is not vacant. The vice chair is Anastasia Taylor. She was elected last meeting. And under a special order of business, it says that there will be election of officers, and that happened last time, so that will no longer be part of the agenda. So, moving on, item B1, approval of action summaries. We have action summaries for Monday, December the 27th, Monday, January 2010, Monday, January 3rd, 2011, Wednesday, January 5th, 2011, and Monday, January 17th, 2011. Could I have a positive motion for approval, please? Mr. Young moves and Ms. Taylor seconds. Is there any objection to approval of the action summaries? Seeing none, the action summary is approved, and we'll move on to the next item, which is disclosures. Are there any disclosures for this evening's proceedings? Mr. Young.
In the case of S11759-2 Sisterhood Park Subdivision, my firm has worked for the petitioner has worked with the petitioner's representative toward common goals. My firm also contracted to the petitioner's firm for or representative's firm for services of various projects. We have no ongoing work with the petitioner or the petitioner's representative, and I have no financial interest or personal interest in the matters before the board. I can remain impartial, in fact, in action as a member of this board without personal bias. My past involvement and personal interest will not prevent me from fairly evaluating the facts of this case.
Thank you. Could I have a positive motion for Mr. Young's participation, please? Thank you, Ms. Taylor, and Mr. Fuller seconds. Ms. Taylor, would you speak to your motion, please?
Based on Mr. Young's ability to remain impartial and unbiased in this case, I motion that he be directed to participate.
Thank you. Are there any other discussion? Is there any objection to the motion? Seeing none, Mr. Young, you are directed to participate in case S11759-2. Mr. Young.
In the case of S11850-1 Powder Ridge tracks track 40-A1 and track B, my firm has worked for the petitioner in the past. My firm also worked for the petitioner's representative in the past. We have no ongoing work with the petitioner or the petitioner's representative. I have no financial interest or personal interest in the matters before the board. I can remain impartial in fact and action as a member of this board without personal bias. My past involvement and personal interest will not prevent me from fairly evaluating the facts of this case.
Thank you. May I have a positive motion directing Mr. Young to participate? Ms. Taylor motions and Ms. Moses seconds. Ms. Taylor, would you speak to your motion, please?
I move that Mr. Young be directed to participate for the same reasons mentioned in the first one.
Thank you. Any other discussion? Any objection to the motion? Seeing none, the motion passes, and Mr. Young, you are directed to participate in case S11850, Powder Ridge Tracts. Any other disclosures? Seeing none, we'll move on to the next item on the agenda, which is the consent agenda. The consent agenda consists of all matters before the board that do not require a public hearing. All items shall be approved by motion without debate. Does any member of the board wish to remove any item from the consent agenda? Seeing none, may I have a positive motion for the approval of the consent agenda? Mr. Story moves, Ms. Taylor seconds. Is there any objection? Seeing none, the motion passes and the consent agenda is approved. There are no items under old business, so we'll go on to new business. During the new business portion of the meeting, we'll follow the procedure that's printed on the front of the agenda. After the staff presentation is completed on an item, the chair I will ask for public testimony on the issue. We'll open the public hearing. Persons who wish to testify will follow time limits established by the rules of procedure. Petitioners, including all of his or her representatives, have 10 minutes. Rebuttal by the petitioner may be allowed when time has been reserved. Representative of groups such as community councils, PTAs, and the like are given 5 minutes, and individuals are given 3 minutes. We keep time by this attractive little timer here on the bench, and the light is green during your testimony. When you have 1 minute left, it turns yellow, and when your time is up, it turns red and buzzer sounds. So if you're not done by then, you need to quickly sum up and be finished. Any individual, when your testimony is complete, you may be asked questions by the board, so you need to stay up at the podium for just a minute until we see if there's any questions. And any individual can only testify once on any given issue. Any individual may have appeal rights related to any action the board takes, and the outline for appeal procedures is on the front of the agenda. So with that, we'll go on to the first case, which is case S11849-1, Ladue Subdivision. May we have staff's presentation, please?
Thank you, Madam Chair. This is a subdivision of Tract F, First Edition to Eagle Crest Subdivision by Plat 6370. It contains 2.10 acres, and it's being subdivided into 9 lots for proposed Ladue subdivision. There is also a request to vacate a 30-foot wide utility easement that runs along the eastern property boundary. This property is located in Eagle River, north of Eagle River Road, on the south side of First Street and on the east side of Birch Lane. The site is zoned R1A. Proposed lot of this subdivision is developed with a single-family dwelling. The wood frame structure that is shown on the plat straddling a number of proposed property boundaries needs to be removed and is planned to be removed. It has to be done prior to recording a final plat. This property was platted in 1963. There was a plat note that stated that this site was reserved for commercial and business uses. However, this property was rezoned during the area-wide rezone to R1A in 1974. That plat note is no longer valid as the development of the property and the use of the property is now governed by the R1A land use regulations. Looking at the design of the preliminary plat, it generally meets the R1A land use regulations as well as the subdivision regulations, except that an 80-foot width is provided for proposed Lot 1. This does not meet the subdivision regulation that requires the width of the lot to be a minimum of 1/3 the depth of the lot. The front yard has been determined to be along the Eagle River Road frontage. Therefore, this section of AMC 218300D lot depth to width ratio would require an 83.3-foot width. Now, the plat can either be modified slightly to meet this standard, or a request could be requested for action by the Platting Board. Lot 1 does have driveway access to the Birch Lane. The driveway access that is shown on the preliminary plat is not proposed to be used by the owner of proposed Lot 1. The access is now to Birch Lane. Lots 2 through 5 front onto First Street, and they will have vehicular access to First Street, which is dedicated to a municipal standard and has been improved. Lots 6 through 9 front onto Eagle River Road. That is a right-of-way that is owned by the state of Alaska. Any driveway permit has to be reviewed and approved by the state of Alaska, Department of Transportation and Public Facilities. In their returned comments, they are intending to limit driveway access to Eagle River Road to 2 driveways. Therefore, there is an easement that is 30 feet by 50 feet, indicating that there will be a shared driveway by lots 6 and 7. That shared driveway needs to be centered on the common property boundary. There will not be allowed 2 driveways to coexist, one serving each lot. So it does have to be along the common lot boundary of lots 6 and 7. The other driveway is to be shared by lots 8 and 9. There is a similar easement shown on the preliminary plat. The state of Alaska mentioned in their comments that they don't need the easement. However, future property owners do need the easement to ensure legal access in perpetuity. So that easement is needed for those shared driveways as shown on the preliminary plat. Public sanitary sewer is available to all 9 lots in the proposed subdivision. Water is located only in First Street and Birch Lane. The lots 6 through 9 do not have access to AWWU water main. There is no water main in Eagle River Road. Therefore, they will have to probably be served by on-site wells. And on-site services does require that documentation of water availability be submitted to on-site services to show that there's adequate water for a well. On each of those lots, there is also needs to be a separation distance from the sewer line as well that will have to be observed when citing those wells. AWW records indicate that Lot 1 already has hooked up to public utilities, water and sewer. There are on-site utilities that will be required to be decommissioned according to code, and those codes are noted in the staff packet. In returned comments from MTA and MEA to the request to vacate that 30-foot utility easement along the east property boundary, the petitioner's representative has worked with those utilities prior to submitting a preliminary plat. He has shown utilities along common lot boundaries and along the east property boundary and south property boundary. In their return comments, both MTA and MEA noted that those proposed easements would probably serve their needs for existing and future utilities. They did not state any objection to the vacation of the 30-foot utility easement. The preliminary plat does appear to conform to Chapters 2175 and 2185. The goals of the comprehensive plan and the applicable land use and subdivision regulations, with the exception that was noted. Therefore, the department does recommend approval of the vacation request subject to the non-objection of all affected utilities, and approval of the preliminary plat subject to the 18 months subject to the 8 conditions found on pages 9 through 11 of the report. Thank you, Madam Chair.
And could we hear from the petitioner or the petitioner's representative, please?
Hi, my name is John Copenhaver. I'm the land surveyor that developed the preliminary plat they have in front of you. I think that a lot of the conditions can easily be met and corrected. And if you have any questions in regards to the subdivision.
Are there any questions for Mr. Copenhaver? Okay.
I think this is a good subdivision, fairly straightforward. And that's it. Yeah, a lot of the corrections can easily be corrected, and when the preliminary plat's resubmitted to the planning department. That's about it.
Okay.
Thank you.
Thank you. Is there anyone else wishing to testify in case S11849-1, the Ladue subdivision? Anyone at all? Mr. Copenhaver, do you have anything else? Oh, wait a minute. Hang on. If you wish to testify, please come forward. State your name for the record.
Yes, ma'am. My name is Brian Tulare. I live right up the street from the subdivision.
Could you spell your last name, please?
Tulare.
Thank you.
And I just wanted to verify that these are going to be single-family dwellings. Okay. That answers a whole lot of questions. Thank you.
Okay.
Sorry.
It's all right. Anyone else wishing to testify in case S11849-1, Ladue subdivision? Anyone at all? Mr. Copenhaver, do you have anything else you would wish to add? You've got over 9 minutes left on your time.
The existing water well has been decommissioned. The well pump was removed. It's no longer in operation. And there was a meeting held with one of the people from the planning department from AWW that the water pipeline would be extended down Birch Lane and then up Eagle River Road to service lots 6 through 9. And in the comments from the Anchorage Fire Department, a fire hydrant will be installed as well. And that's in regards for water availability for those frontage lots. But that'll be handled when development of those properties before they are commenced. Yeah, I think that's what I have. Thank you.
Anybody else have any questions for Mr. Fuller?
Staff mentioned here on number 4 about redesigning the plat for the width of Lot 1 or submitting for a variance. And are you at this time requesting a variance or for the width of that lot?
I think there's enough, the lot widths of those 5 lots could be adjusted to meet the adequate. So I don't think that would be necessary.
Thank you.
Any other questions for Mr. Copenhagen? Mr. Young?
Yes, thank you. Did I understand you correct that water will be brought in along Eagle River Road for lots 6 through 9?
There's a water line that goes down Birch Avenue. It goes down about halfway down on the west boundary of Lot 1. The water main goes down about halfway down, and from there it would be extended the rest of Birch Lane, and then subsequently eastward up Eagle River Road to service lots 6 through 9.
Thank you.
You're welcome.
Anything else for Mr. Copenhagen? Thank you for your testimony.
Thank you.
So we'll close the public hearing, and the matter rests with the board. Could I have a positive motion regarding the request for vacation? Ms. Taylor, is there a second?
Actually, before I motion, I'm wondering, is it appropriate to ask questions of staff before I motion? I'm not sure if I'm ready to motion.
About that part.
Okay. Through the chair, staff, are you comfortable with the conditions as written to cover a potential agreement with AWU for that water line extension?
Madam Chair, Ms. Taylor, my understanding of this is that, and of on-site systems in the meeting, typically extension of a main line is the responsibility of the developer. And AWWU, I was in a meeting with AWWU, and I heard something different from that which the petitioner's representative. I'm not sure if there's a misunderstanding, but I understood that the cost of extending a main line would be so prohibitive that it's likely that those lots would be served by on-site wells. Because I know of no plans, and there certainly were no comments in AWWU's returned comments that they planned to extend that water. And I understood the AWWU representative to say they're not going to extend the water. It would be the responsibility of the developer. Thank you.
So I want to make sure that the petitioner has flexibility to go with either the water well option or the municipality's interest is protected by putting a resolve comment in. Would that be appropriate here to ask the petitioner to resolve with AWU the need to extend the water line down Eagle River Road?
Will this be a part of the vacation motion, or is it a part of the plat motion?
Part of the plat motion, if I were to put it in there. I don't know if I need it, though, or not. If they don't go with water wells, then what?
Madam Chair, Ms. Taylor, typically the condition would actually read, entering into a mainline extension agreement with AWWU if water is to be provided to lots 5 through 9. So one could say, with that caveat, if public water is to be provided to lots 9 through 9, it's not actually you must do this, but it allows them to do it. The AWW water distribution system map is on page 19 that shows the water line going midway down Birch Lane. That would be, a water main would have to be extended down Birch Lane and then extended the entire, practically the entire length of the south boundary. And that would be a very big cost for the developer to undertake that. On page 77 are the comments from AWWU. And under Ladue subdivision, it's on page 77, under Ladue subdivision, item 2, their comment reads, if public water service is desired for lots 6 through 9 by the owner or required by the platting authority in accordance with 2185-160, the owner will be required to enter into mainline extension agreements with AWWU. To me, that indicates that is the responsibility of the developer. The planning department is not going to force somebody to assume that cost if a water well is a viable alternative.
Are there any other questions of staff? Okay, seeing none, then Ms. Taylor, did you want to continue on with your motion on the vacation, or did you just want to ask questions?
In the matter of case S11849-1, Ladue subdivision, I motion for the approval of the request to vacate the 30-foot wide utility easement along the east boundary of existing tract F, first addition to Eagle Crest subdivision, subject to the non-objection of all affected utilities.
And now that we've heard the motion, Mr. Fuller, do you still wish to second? Thank you. Would you speak to your motion, Ms. Taylor?
I believe this is a very straightforward subdivision, and if the utilities don't have a problem with the vacation, I don't either.
Are there any other comments? Any other discussion? Is there any objection to the motion? Seeing none, the motion passes and the vacation is approved. Moving on to the plat. Ms. Taylor?
In the matter of case S11849, Ladue subdivision, a motion for the approval of the plat for 18 months subject to conditions 1 through 8 on pages 9, 10, and 11. I would like to add a condition 9. Resolve with AWU the need to enter into a mainline extension agreement if water wells are not a viable option. And I would like to correct on condition 7C. It says in a plat note, it references Rabbit Creek Road, and I would like to correct that to read Eagle River Road.
Is there a second? Mr. Young seconds. Would you speak to your motion, Ms. Taylor?
Again, I believe this subdivision is very straightforward, and I'm adding the AWU condition just in case, for any reason, water wells do not work for the subdivision, then AWU can help you get a mainline extension.
Is there any other discussion? Is there any objection to the motion? If not, the motion passes and the plat is approved for 18 months subject to the conditions 1 through 9 and the number 7 as it was, number 7C as it was corrected. Okay, Okay, the next case is case S11850-1, Powder Ridge Tracts, Tract 40-A1 and Tract B subdivision. Yeah, Tract 1B. May we have staff's presentation, please?
Thank you, Madam Chair. This case is a request to subdivide approximately 403 acres of Tract 40A Powder Ridge subdivision into two tracts, Tract 40A1 and Tract B Powder Ridge tracts. Tract 40A1 will contain 388.21 acres, while Tract B will contain the remaining 15.71 acres. This property is located in Eagle River, north of Eklutna Park Drive and west of Terrace Lane. Both proposed tracts are currently undeveloped. Tract 40A1 and Tract B are zoned PC, planned community, and will be subject to the provisions of AMC 2140-250. Zoning in the surrounding area includes R2A, two-family residential, and R3, multifamily residential. Development ranges from single-family homes to townhouses to commercial apartments. The purpose of this plat is to prepare a site for acquisition by the Anchorage School District for the construction of an elementary school in approximately 15 to 20 years. Proposed Tract 40A1 contains Class A, B, and C wetlands. Any future development within the wetlands will require authorization from the Army Corps of Engineers. Long-range planning staff requests a plat note indicating a 100-foot setback from Fire Creek where it is contiguous with the wetlands. This is the minimum setback as indicated in the Wetlands Management Plan. Watershed Management requests an additional stream mapping on proposed Tract 40A1 to be done this spring. This is done to resolve the need for stream setbacks and drainage easements. With that said, the Department recommends approval of this plat for 18 months, subject to the conditions 1 through 3 on pages 7, 8, and 9 of your staff packet. However, I'd like to offer one friendly amendment to condition 2E. That condition should state property owners or utilities shall not raise, lower, regrade, or regrade the property in a manner that will alter drainage patterns from those existing at the time of application for case S11850-1 without prior approval from the Municipality of Anchorage Building Safety Office. Thank you.
You okay with that, or do you want it again?
Would you like me to repeat that?
Yes, please.
That condition should state property owners or utilities shall not raise, lower, or regrade the property in a manner that will alter drainage patterns from those existing at the time of application for case S11850-1 without prior approval from the Municipality of Anchorage Building Safety Office. Thank you.
Thank you. Are there any questions of staff? Ms. Taylor.
Through the chair, do we have any documentation of what those existing drainage patterns are right now as a reference point?
The only drainage patterns that are the topography on the plat indicates that there are drainage patterns, and Watershed Management is requesting additional mapping.
Thank you.
Thank you. Any other questions of staff? Seeing none, we'll open the public hearing, and could we hear from the petitioner or the petitioner's representative, please?
Good evening. My name is Wendy Wilbur. I'm with CRW Engineering, and I'm here representing Eklutna, Inc. and also the Anchorage School District. Thank you in advance for your time. We are here tonight to do a very simple tract plat and to fill a long commitment to the Chugiak Eagle River community. This sets aside a 15-acre tract for a future school site. This school site has been identified in the Eagle River Comp Plan, and it is also identified in the adopted master plan for the PC zoning for the Eklutna Powder Ridge development. and recognized in the zoning ordinance which governs this PC development, which is AO 2007-6. In addition, this summer we went through a site selection process and evaluated over 5 sites. This site was overwhelmingly recommended by the Anchorage School Board, the Planning and Zoning Commission, the Assembly, and the Birchwood Community Council. So tonight we bring to you this simple tract plat. We have no concerns with any of the conditions, but would like to offer one clarification to condition 3A, which states, please correct the plat to identify the wetlands designation A, B, and C per the Anchorage Wetlands Management Plan. We would simply like to add a note that says these wetlands are not field delineated and are subject to field verification. Should I repeat that, or are we good?
You can repeat it one more time.
Okay, so we'd like to add a note that says the wetlands have not been field delineated and are subject to field verification. And additionally, I would like to note that we will work with watershed management to resolve the drainage ways. Again, this entire parcel is 388 acres if you do tract A, 15 for the school district. There are no subdivision lots at this time. There's no development planned. The school district is 15 to 20 years away. We will resolve within the watershed management can come out and map these drainage ways. But until there's actual development, it's hard to set aside any easements or actually deal with them in any way. So we don't have any problem working with watershed management to resolve those issues. And that's all I have for now. Questions?
Any questions for Ms. Wilbur? Doesn't look like it. Thank you.
Thank you.
You have 7 minutes, 15 seconds for rebuttal. Anyone else wishing to testify in case S11850 Powder Ridge Tracks? Anyone at all? Would you care to add anything more? Okay, she indicates not. So we'll close the public hearing. And are there any questions of staff? Okay, seeing none, could I have a positive motion regarding the plat? Mr. Story.
In the case of S11850-1, Powder Ridge Tracks, Track 40-A1 and Track B, I move for the approval of the plat for 18 months, subject to conditions 1 through 3, pages 7, 8, and 9, with the following modifications. To condition 2E, I would like to change the wording to the staff's recommended modification to the plat note. And to condition 3A, I would like to add the petitioner's wording. The wetlands are not field delineated and are subject to field verification.
Mr. Fuller seconds. Would you speak to your motion, Mr. Story?
Based on the agreement from the petitioner's representative and the department's review and recommendations, I support the approval.
Is there any other discussion? Is there any objection to the plat? Seeing none, the motion passes and the plat is approved for 18 months, subject to the amended conditions as stated. Moving on to the last case under new business, case S11851-1, Simonson Tract Subdivision. May we have the staff's presentation, please?
Thank you, Madam Chair. This is a subdivision of a portion of one unsubdivided tract of land into one different tract of land with a waiver request for AMC 2115-110A that basically prohibits a plat that results in a remnant parcel. This preliminary plat contains 3/4 of an acre, and the petition site is zoned R1A. The purpose of this plat is to create a tract for an existing AWWU sewer pump station. The property is located north of West Marston Drive on the east side of Pete's Place, which provides vehicular access to the site. This is a fairly straightforward plat. The utility substation is a conditional use in the R1A zoning district. This was granted by the Planning and Zoning Commission in 2007. Now, it should be noted, referring to the map on page 116, which is the map for the boundary of the conditional use permit, yes, 116, that the conditional use permit applies to that entire tract of land that is north of lots 1 through 8 in the Turnagain subdivision, Simonson Estates subdivision. The petitioner does need to submit a minor amendment to the Planning and Zoning Commission for a non-public hearing review of, for a request to amend the boundary of the conditional use permit so that it will indeed follow or match the proposed boundaries of the new tract that would be created with this plat. This site is occupied. It's a very small pump station. It's 450 square feet, 18 feet by 25 feet. It is set away from the residential development, and vehicular access for maintenance purposes is, as I mentioned, via Pete's Place, which adjoins the west boundary of the current petition property. The petition site is part of a strip of land that extends to the mean high water mark, located north of lots 1 through 8, Block A, Simonson Estates subdivision. This area is also known as the Turnagain Slide area. Now, the property for this particular plat was acquired through eminent domain for a public purpose, as the pump station does serve a significant portion of the West Anchorage neighborhoods. In 2008, the Superior Court ordered that Anchorage is authorized by law to acquire the property for a public use. Now, the strip of land extending to the mean high watermark was the subject of a series of court cases which ultimately determined the ownership of that strip of land that was vested in the owners of the lots of 1 through 8. In a separate action, the Superior Court did establish the boundary of the easement for the Tony Knowles Coastal Trail. That coastal trail is depicted on the preliminary plat, and it is identified by the court order and the number of that court case from the Superior Court. This waiver is requested to allow the recording of this final plat that will formally establish the boundary of the property that was acquired through the eminent domain process, without having to replat the entire parcel extending to the mean high water mark. AWWU has no jurisdiction over this land and has no authority to replat the property. A request by the plaintiffs in that court case that established the ownership for that strip of land north of lots 1 through A, and a request for the court to establish the boundaries for each individual lot, and also to order a replat, was denied by the Superior Court. The court found that this was ultimately the responsibility of the individual owners of lots 1 through 8 to replat their property. This is an unusual situation. Typically, a remnant parcel is not allowed to be created through a platting action. But because of the court actions and the very specific action by Superior Court vis-a-vis the platting of this property, the department does recommend approval of that waiver from AMC 21-15-110A to allow this plat to be recorded without recording the entire strip of property, and does recommend approval of the plat subject to the 4 conditions that are found on pages 8 through 9 of the report. Thank you, Madam Chair.
Thank you, Ms. O'Brien. Are there any questions of staff? Ms. Taylor.
Through the chair, if we do not approve this tonight, what are the consequences for AWU?
Madam Chair, Ms. Taylor, the pump station was constructed last year. It has existed for a year. But the actual consequences for AWW, I believe there is an AWW representative here tonight. Oh, thank you, because I couldn't answer that question.
Any other questions of staff? Okay, seeing none, we'll open the public hearing, and could we hear from the petitioner or the petitioner's representative, please?
Hello, my name is Steve Nuss. I'm the Capital Program Manager for the Anchorage Water and Wastewater Utility. We were first before you regarding this parcel back on January 4th, 2006. So it has been approximately 5 years that AWW has been trying to resolve the acquisition and platting of this parcel. And it's actually been over that because we started looking at this parcel back in 2004. Ms. O'Brien summed up the kind of the history of this parcel very nicely in the process that we had to go through to acquire this property. The action before you tonight helps us clean up our eminent domain acquisition of this parcel. It brings us in compliance with both municipal code and state statute that requires that we subdivide the parcel and properly plat it. And so in terms of consequences to us, it extends out the process even longer than it already has been. Time is money, but it depends on how long you want to extend it out for. We originally had a preliminary plat on this parcel, slightly different configuration. We extended it out multiple years through the condemnation process. We kind of let that all go behind us, and we're here tonight before you trying to finally resolve the land acquisition for us. In terms of the conditions and the recommendations made by staff, Anchorage Water and Wastewater Utility takes no objections to the conditions requested by staff for plat notes or to go back to the Planning and Zoning Commission and resolve our issue there with conditional use permit. Did want to take the time here to address the one public comment that was received on this parcel about the development and extension of utilities to this parcel. Through the construction of our Pump Station 10 project, we did extend water, sewer, gas, and electrical utilities through Pete's Place and down to our lot and fronted all adjacent lots that we passed going down to our facility here. So we have been working very much within the requirements of code and title to extend utilities through the subdivision of a parcel, even though we had not fully subdivided the parcel at that time. With me tonight is Vern Rolfs, the surveyor that did the survey. He can answer any real technical questions regarding the plat itself. There's members of the Turnagain Community Council here tonight. I reserve my time, if I could reserve the remainder of my time for any rebuttal or to answer any more questions of the board. And that's it for me for right now. Thank you.
Thank you. Are there any questions for Mr. Nuss? Okay. Thank you. Anyone else wishing to testify in case S11851-1 Simonson Tract Subdivision Tract 1?
Yes, I would like to. I have some comments. Well, for the record, my name is Breck Tostovan. I'm the past president of the Turnagain Community Council and a member of its board of directors. And I've been before the board before in 2006 on the first plat that AWW presented. And the Turnagain Community Council doesn't have a problem with the pump station or the location of the pump station. That's all past us. We do have concerns about the waiver of the requirement that you subdivide the entire this entire piece of strip of land. And I think if you look at Judge Span's decision, what he said in that decision was that this, well, first of all, you have to understand that essentially this extra piece of land, this strip of land, was created by the earthquake. The original lots of those subdivisions, the lines were drawn on the top of the bluff. And what happened is the bluff then slid and created more land. And what the lawsuit was about was who owned that additional land. Well, Judge Span said that the original plat was ambiguous. He said it was not clear whether the plat went out to the mean high water or not. So all that Judge Span said was, okay, these lot owners own this extra land, but he said that the plat was ambiguous. So essentially this strip of land has never been platted by anyone. And so what AWW is asking you to do is basically do an illegal subdivision. I mean, they took this piece by eminent domain, so I don't think there's any harm to them with you saying you've got to plat this piece of land. Essentially the problem is you're going to have a big problem on your hands because we're going to have this. I mean, what are the lot owners going to do? You have a piece of land with no lot lines on it. The other problem is that AWW's preliminary plat shows the location of the coastal trail with respect to its land, but the location of the coastal trail isn't shown on the remnant. So staff mentions that they believe that Judge Span made some decision about whether the land needed to be replatted or not. He essentially didn't. I don't agree with that. He didn't say you had to plat it or not. He's basically leaving that to the municipality to decide platting. I think platting is up to you. He basically did not order the either party to go plat the land. He just simply said, I'm not going to order anybody to plat the land. So I think the important point is that this piece of strip of land was created by the earthquake. It's never been platted. Judge Span found the original plat to be ambiguous. He said that the lines, the meets and bound lines were not valid. He found that it went all the way out to the mean high. So anyway, so we would urge you to deny the waiver. We're not trying to impose, burdens or costs on anybody. We just think that this is a lingering problem since the earthquake and that we should just do this right. Any questions? And I'd reserve any time I have left so I could respond to what Steve has to say.
We have a minute and a half left, but stick around.
Okay.
Question. Ms. Taylor.
Thank you. Through the chair, have you heard from any of the other landowners on lots 1 through 8 about their involvement in this or their intentions?
My understanding is that some of them are going to resurvey their lots and do records of survey or something, but I don't think that's going to create a plat or a land record that the public and future owners can depend on. I think it's just going to create a mess.
Mr. Fuller?
Yes, through the chair. This obviously has happened before. I mean, this happened in a lot of areas. Has it been resolved in other instances of this?
Other areas like the slide created by the earthquake? Not that I'm aware of.
Any other questions, Mr. Thompson? Thank you.
Thank you.
Anyone else wishing to testify in case S11851-1?
My name is Cable Starlings. I'm an owner of Pete's Lot 1. I'm part of the whole development, the road improvement district that was constructed in that area. I'm speaking in favor of the petition. I'm one of the many other owners that are involved in this area that have been waiting in order to build our homes in that area. And the delay of this platting and where this all resides itself needs to be completed. And the reason I say that is that this municipality, through the RID and WID process, has an estimated cost for each owner, each lot owner that's going to be assessed. They haven't been able to do that assessment for now 2 years because this has been pending. So as an owner, another owner in that same development, not in the 1 through 8, I'm not in Simonson, I'm in the Pete's lot area. Pete's Lot 1 is my lot. And we need to get this resolved and over so that the assessments can be done for the WID and the RID so that we can get on with building our homes in there. This is just an ongoing stumbling thing that I think it needs. I think their idea. I support the platting request for the pump station. Let the owners, pay the cost of having it replatted, as I think the judge was recommending in that. He said the city's not going to bear the cost of that. The other owners aren't going to bear the cost of that. They should bear the cost of that. And I believe that's what he was saying, that they shouldn't order AWWU to do that with theirs. So that's my comment.
Any questions for Mr. Starlings? No questions? Thank you for your testimony. Anyone else wishing to testify in case S11851-1 Simonson Tract Subdivision, Tract 1? Anyone at all? Okay. Mr. Nuss, you have 7 minutes.
Okay. I'd like to address a couple things. One, with regards to the platting of the additional parcel, the remnant tract. One of the things, if you look at page 107 of the packet here, item 4 underneath Judge Spann's declaration was, plaintiffs request that this court direct the preparation of a new plat. If the parties wish a new plat reflecting their ownership of the disputed parcel of land, then they should prepare and record such a plat. When Judge Spann awarded, or not awarded, but found in favor of the property owners of lots 1 through 8, he did not apportion ownership of the remnant tract to individuals. He apportioned it to them as a whole for them to sort out their ownership issues. To my knowledge, those ownership issues have not been resolved, and that's one of the things that's holding up those individuals from being able to prepare their plats or their replats and ultimate configuration of whether or not they want to reconfigure their lots 1 through 8 and extend them down through that remnant tract, if they want to own that remnant tract in whole as some sort of homeowners association. Those kind of decisions are outside the ability for AWWU to be able to control, determine, and let alone be able to wrangle together all those interests and have them all come to an agreement for AWWU to be able to affect our platting of our property. So that is why the request for the waiver was made, and that is also why planning staff supports that request. With regards to bringing this to close, we do need to bring this to close. Time does cost money. Mr. Sterling's comments about assessments. It's not really tied to this project. This is a separate project. This benefits the overall area, but the costs of this project do not reflect onto his assessments, though that project has been open for some other reasons there. So I appreciate Mr. Sterling's support of it, but some of the reasonings there aren't exactly correct, as this project does not affect his costs. If there's any other questions of the board, I'd be happy to answer them at this time.
Ms. Taylor.
Thank you. Through the chair. If you bear with me a bit, I want you to understand where I'm coming from with this. I think that eminent domain is something that we rarely see, and it's got a lot of baggage that goes with it. So I understand your desire to clean up the paperwork on it, but at the same time, I want to leave the people that are involved in this every opportunity and every flexibility to do what they can with what remains of the land. So I'm curious, is there any way for the petitioners to still have AWU at the table as far as when they replat this? Are they going to want access? Are they going to want utilities across your lot? Can you still be involved in any way and get what you want tonight and yet leave the flexibility for them?
It's ultimately up to them. If they come in with a plat and they want, depending upon what they want to do, it would be not unlike any other subdivision or plat before you that comes in an application that goes out to AWW. If they wanted utilities, they would come in and discuss with it how they would propose to extend the utilities. Lots 1 through 8 have been served by utilities. We do have in here utility easements going down Pete's Place for our stuff. There is an easement between lots 3 and 4. Is that lots 3 and 4? 2 and 3 for sewer lines as well. So they can work with us. It's just a matter of what they want. And when they decide what they want, then yes, we will work with them to help them achieve their goals.
Any other questions of Mr. Nuss?
Thank you.
Thank you. Ms. O'Brien, did you have a comment?
Madam Chair, I was going to direct you to page 107, and Mr. Ness did that. And he, on 107, it's item 4, where the court did say that it was, the disputed land was the responsibility of the owners. But the paragraph above that is interesting, number 3. The plaintiffs asked that the court declare their interest to be prior to and superior to all other persons. That tells me that they have, and the court declared that the plaintiffs and third-party defendants' rights to the disputed strip of land are paramount to those of the defendants. The municipality was a defendant. So that paragraph tells me that the ultimate responsibility for replatting the property ultimately resides with the owners of Lot 1 through 8 because their interests are superior to everybody else's interests, with the exception of the coastal trail, which the court addressed in a separate action, and that they are the only ones that can actually resolve the boundaries of their individual lots and their ownership in the landslide area.
Thank you. Any other, let's see. Okay. I'm going to close the public hearing, and the matter rests with the board. Any other questions of staff? Seeing none, could I have a positive motion on this? Starting with the request for waiver. Mr. Story.
In the matter of case S-11851-1, Simpson Estates subdivision, I move for the approval of the request for the waiver from AMC 21.15.110.A that requires replatting of all contiguous properties in common ownership.
Is there a second? Ms. Moses seconds. Mr. Story, would you speak to your motion, please?
I do believe that this is unusual circumstances, as indicated in our packet and further described by the petitioner and by staff. I do believe that the replatting of lots 1 through 8 is a separate issue, and I do believe that it's appropriate to move forward with the approval of the waiver.
Any other discussion? Ms. Taylor?
I think I'm going to disagree on this one. I will not be supporting this request for the waiver, and I'm going to use the judge's language to support my argument that the rights of the landowner take priority over the rights of the municipality, and I equate AWU to be the municipality on this one. I think that the final configuration of that strip of land needs to be resolved, and I think if AWU is sitting at that table when it's resolved, then it's a better situation than them coming in here and getting their first dibs whack at it. They've got the pump station, they've got the court order that determines what it is, but the landowners, I want to leave them the flexibility when they reconfigure that strip of land to have all interested parties there. They may want access down Pete's Place, they may want who knows what. I would leave it open to the landowners, and I would want everybody sitting at that table. And when AWU says that they could come in and after this plat, if we grant this, and AWU says they could come in after the plat and ask for concessions, permissions, and access, it's certainly not the same when you come in to AWU after somebody, has already gotten what they're looking for. It's being an applicant is not the same as being a cooperative partner in figuring out what's going to happen with this strip of land.
Any other discussion? Mr. Fuller?
Where are the other owners of lots 1 through 8? Why are they not here with a position relative to this, which would significantly impact their future rights? I mean, we are not in control of them, and I'm sure they're noticed about this. I suspect they're noticed. Maybe staff could say whether they're noticed on this particular plat. Margaret? Sorry. Are the other owners, lot 1 through 8, are they aware of this plat being submitted?
Madam Chair, Mr. Fuller, public hearing notices were mailed out to property owners within 600 feet of the outer boundaries of this petition site.
Thank you.
Any other discussion? Since there's opposition, then we need to vote mechanically. And a yes vote will support an approval of the waiver, and a no vote will support denial of the waiver. That motion passes. 5 positive votes were required for passage, and we have that. So moving on to the plat. Mr. Story?
In case S-11851-1, Simpson Estate Subdivision, I move for the approval of the plat for 18 months, subject to the following conditions, 1 through 4, pages 8 and 9.
Is there a second? Would you? Oh, okay. Mr. Young seconds. Thank you. Would you speak to your motion, please?
I based on the agreement from the petitioners and the department's review and recommendations and our information provided in the packet, I support the approval of the plat.
Any other discussion? Any objection to the motion? Seeing none, the motion passes and the plat is approved for 18 months, subject to the stated conditions. So that's the end of the new business portion of the agenda. No appearance of requests that I'm aware of. No persons to be heard. No reports. Are there any board member comments? I'd like to welcome Ms. McKenzie to the Platting Board.
Thank you.
You're welcome. Seeing none? Didn't get a motion, but